2022 of the House of Commons Standing Committee on Finance. Pursuant to the motion adopted in committee on Thursday, February 17th, the committee is meeting to study the invocation of the Emergencies Measures Act and related measures. Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. So you are aware, the webcast will always show the person speaking rather than the entirety of the committee. Today's meeting is also taking place in the webinar format. Webinars are for public committee meetings and are available only to members, their staff, and witnesses. Members enter immediately as active participants. All functionalities for active participants remain the same. Staff will be non-active participants and can therefore only view the meeting in gallery view. I would like to take this opportunity to remind all participants of this meeting that screenshots or taking photos of your screen is not permitted. Given the ongoing pandemic situation in light of the recommendations from the health authorities, as well as the directive of the Board of Internal Economy on October 19th, 2021, to remain healthy and safe, all those attending the meeting in person are to maintain a 2-meter physical distancing, must wear non-medical mask when circulating in the room, and it's highly recommended that the mask be worn at all times, including when seated. Must maintain proper hand hygiene by using the provided hand sanitizer at the room entrance. As the chair, I will be enforcing these measures for the duration of the meeting, and I thank members in advance for their cooperation. To ensure an orderly meeting, I'd like to outline a few rules to follow. Members and witnesses may speak in the official language of their choice. Interpretation services are available for this meeting. You have the choice at the bottom of your screen of either Floor, English, or French. If interpretation is lost, please inform me immediately and we will ensure interpretation is properly restored before resuming the proceedings. The raise hand feature at the bottom of the screen can be used at any time if you wish to speak or alert the chair. For members participating in person, proceed as you usually would when the whole committee is meeting in person in a committee room. Keep in mind the Board of Internal Economy's guidelines for mask use and health protocols. Before speaking, please wait until I recognize you by name. If you are on the video conference, please click on the microphone icon to unmute yourself. Those in the room, your microphone will be controlled as normal by the proceedings and verification officer. When speaking, please speak slowly and clearly. When you're not speaking, your mic should be on mute. A reminder that all comments by members and witnesses should be addressed through the chair. With regard to a speaking list, the committee clerk and I will do the very best we can to maintain consolidated order of speaking for all members, whether they are participating virtually or in person. This meeting is scheduled for a longer duration today in consideration of the fact that our witnesses may not get an opportunity to leave their virtual setup at around the halfway duration of the meeting. I'll suspend the meeting for a 5-minute health break. Members, just before I introduce the witnesses, I do understand that we have an agreement amongst our committee to speak about the situation in Ukraine. And I do see that PS Beach's hand is up. PS Beach.
Mr. Chair, thank you for giving me an opportunity to speak and address the news of Russia's unprovoked attack on Ukraine. Our government, the Prime Minister and the Deputy Prime Minister, condemn in the strongest possible terms Russia's egregious attack on Ukraine. These unprovoked actions are a clear further violation of Ukraine's sovereignty and territorial integrity. They are also in violation of Russia's obligation under international law and the Charter of the United Nations. Canada calls on Russia to immediately cease all hostile actions against Ukraine and withdraw all military and proxy forces from the country. Ukraine's sovereignty and territorial integrity must be respected, and the Ukrainian people must be free to determine their own future. Earlier this morning, the Prime Minister met with G7 partners, and our government will continue working closely and quickly with NATO and our allies to collectively respond to these reckless and dangerous acts, including by imposing significant sanctions in addition to those already announced. In the face of these attacks on Ukraine, Canada will take additional action to stop Russia's unwarranted aggression. We continue to stand with Ukraine, its people, and the Ukrainian Canadian community here in Canada. Russia's brazen acts have profound human consequences and will not go unpunished. With your permission, Mr. Chair, I'd invite my other honorable colleagues to speak if they would care to do so. Thank you very much, Mr. Chair.
Thank you, PS Beach. And I do have hands up. I've got MP Lawrence and then MP Samari and then MP Blakey after that. MP Lawrence.
Thank you, Chair. And we share in the government's condemnation of this unprovoked attack on the people and the country of Ukraine, of which the attack is a violation, of course, of Ukraine's sovereignty. It's also a violation of international norms and of the system of which Canada's and the Western world's prosperity has been built on, the most prosperous time in recent history. Putin must immediately cease this attack and withdraw all military forces. For failing to do that would undermine the international system, which Canada has played a key part in establishing after World War II, and as I said, has been the foundation of our peace and prosperity. As Canadians, we need to commit ourselves to strengthening our own security, including the Arctic, and to the renewal of commitments to NATO. Conservatives, parliamentarians, and Canadians all stand with the Ukrainian people in this, one of their darkest hours. Our thoughts and prayers are with the people of Ukraine.
Merci, MP Lawrence.
Thank you, Mr. Lawrence.
MP Samari.
Oui, merci, Monsieur le Président.
Yes, thank you. Thank you, Chair, colleagues. I take my turn to speak, to vigorously speak against what is happening in Ukraine. People will die, civilians will die, the military will die as well, and the Ukrainian population is being attacked, bombarded, invaded. We never thought that we would see a world in war again, but war in Europe is a fact now. We stand shoulder to shoulder in solidarity with the Ukrainians people, and this is a very, very sad day for humanity, for history. It's not too late to stop this madness, but I'm not sure that it will stop. So I say to the Ukrainian people, we are beside you with all our hearts. We will do everything we can to help you. We respect you and know that you are not alone in this matter.
Merci, MP Sam.
Thank you, Mr. St. Marie.
Hear from MP Blakey.
Thank you very much, Mr. Chair. I want to take this opportunity to condemn in the strongest possible terms the actions of Russia in violating the sovereignty and the territorial integrity of Ukraine, and call on Russia to cease all aggression against Ukraine and withdraw all of its troops. Our thoughts right now as Democrats, members of the House of Commons, and Canadians are with the Ukrainian people who are suffering this invasion of their country, and all of the people here in Canada and across the world who have friends and loved ones in Ukraine who are worried about their well-being. I think this also tells us something important about Russia under the leadership of Vladimir Putin. And we have to recognize that the war isn't just happening physically, but we also know that Russia has been very active in the digital space in Ukraine and indeed here in Canada, spreading disinformation, and that Russia's actions in the Ukraine are also related to a larger campaign to sow discord in the West. And I think that's something that we need to bear in mind and to be cautious of the influence that Russia is having here at home through social media and other avenues where it can spread disinformation to try and keep people distracted while it pursues a very real agenda of territorial expansion in Ukraine. So thank you for the opportunity to put these thoughts on the record at a very bleak time in the world's history, Mr. Chair.
Thank you, MP Blakey. I do see MP Lawrence's hand up. MP Lawrence.
First, I'd like to thank all the members for their excellent statements. And then the second, because we were unable to get the RCMP here today, and we just have FINTRAC, and they already testified at some length at the Public Security Committee. I'm wondering if we could move this from a 3-hour meeting to a 2-hour meeting.
Okay, I'm seeing a lot of hand clapping, thumbs up, and from everybody, and so. We love you, FINTRAC, but yes, 2 hours is the time we will have with FINTRAC today. And members, thank you, MP Lawrence, and members, thank you for those bold, strong statements showing Canada's support for Ukraine. I could tell you here at home, my wife is of Ukrainian descent, and in my riding of Mississauga East Cooksville, we have a large Ukrainian diaspora community. So Slava Ukraini. Slava Canada, and I hope I said that right, and I'll hear from MP Baker on that, I am sure. So at this time, I would like to introduce our witnesses, or witness that we have today. We have FINTRAC with us, and I'll just read out the Financial Transactions and Reports Analysis Center of Canada. We have Donna Achimov, and I apologize if I mispronounced that, Ms. Achimov, the Deputy Director, Chief Compliance Officer, Compliance Sector, and Barry McKillop, the Deputy Director of Intelligence. And you will now have an opportunity to make an opening statement for members, and then we will go to questions. Thank you.
Thank you, Mr. Chair, and I'd like to start by acknowledging just the statements of the members on the situation in Ukraine. And I want to thank you, Mr. Chair, for inviting FINTRAC to participate in your review of the Emergencies Act, which was revoked by the federal government yesterday afternoon. As you mentioned, I am joined today by Donna Achimov, who is our Chief Compliance Officer, as well as the Deputy Director responsible for compliance. Monsieur le Président, comme les membres du comité.
Mr. Chair, as committee members know, FINTRAC is Canada's financial intelligence unit and anti-money laundering and anti-terrorist financing regulator. We are responsible for ensuring compliance of more than 24,000 businesses that have requirements under the Proceeds of Crime, Money Laundering and Terrorist Financing Act, including financial institutions, casinos, money services, businesses, and others. FINTRAC has a robust, risk-based approach, compliance program in place to ensure that businesses fulfill their requirements, such as identifying clients, keeping records, and reporting certain types of financial transactions, including international electronic funds transfers, large cash transactions, large virtual currency transactions, and suspicious transactions.
Businesses subject to the Act, and when appropriate thresholds are met, FINTRAC provides actionable financial intelligence to Canada's police, law enforcement, and national security agencies in support of their money laundering and terrorist financing investigations. Our financial intelligence disclosures are often based on hundreds or even thousands of financial transactions. These disclosures may show links between individuals and businesses that have not been identified in an investigation and may help investigators refine the scope of their cases or shift their sights to different targets. A disclosure can pertain to an individual or a wider criminal network and can also be used by police and law enforcement to put together affidavits to obtain search warrants and production orders. In total last year, FINTRAC provided more than 2,000 disclosures of actionable financial intelligence in support of investigations related to money laundering, terrorist activity financing, and threats to the security of Canada. Since becoming operational in 2001, the Centre has provided more than 22,000 financial intelligence disclosures to Canada's police, law enforcement, and national security agencies. In 2020-2021, our financial intelligence contributed to 376 major resource-intensive investigation and many hundreds of other individual investigations at the municipal, provincial, federal, and international levels. These agencies continue to seek our financial intelligence in record numbers. FINTRAC received 2,109 voluntary information records from Canada's police, law enforcement, and national security agencies last year. These records contained information on alleged criminals and terrorist financiers, and are often the starting point for our analysis and the financial intelligence that we are able to generate and disclose. Many of the recipients of our disclosures have told us that they will not start a major project level investigation without seeking out our financial intelligence. Mr. Chair, under the Emergency Economic Measures Order, certain businesses, including financial entities, money services businesses, crowdfunding platforms, and payment service providers, were required to take specific actions in relation to the financial activity of individuals that were engaged in the blockades as laid out in the emergency measures regulations. For example, crowdfunding platforms and payment service providers were required to register with FINTRAC when they were in possession or control of property that was owned, held, or controlled by an individual or entity that was engaged in an activity that was prohibited in the emergency measures regulations. Following the invocation of the Emergencies Act, a number of crowdfunding platforms and/or payment service providers did begin the registration process with FINTRAC. This has, however, now been halted with the revocation of the Emergencies Act. Crowdfunding platforms and payment service providers that were required to register with FINTRAC were also required to report suspicious transaction reports, large cash transaction reports, international electronic funds transfers reports, and large virtual currency reports when thresholds set out in the Proceeds of Crime, Money Laundering, and Terrorist Financing Act and its regulations were met. This too has been halted with the revocation of the Emergencies Act. As a financial intelligence unit and under our legislation, we cannot speak to the reporting that we receive from businesses or the financial intelligence specifically that we provide to Canada's police, law enforcement, and national security agencies. Mr. Chair, I want to be very clear about FINTRAC's mandate. As one of 13 federal departments and agencies that play a key role in Canada's anti-money laundering and anti-terrorist financing regime, FINTRAC was established as an administrative financial intelligence unit and not a law enforcement or investigative agency. We do not have the authority to monitor or track financial transactions in real time, freeze or seize funds, ask any entity to freeze or seize funds, or cancel or delay financial transactions. This was done very deliberately by the Parliament of Canada to ensure that we would have access to the information needed to support the money laundering and terrorist financing investigations of Canada's police, law enforcement, and national security agencies while protecting the privacy of Canadians. And this did not change under the Emergencies Act or the Emergency Economic Measures Orders. Monsieur le Président, nous sommes déterminés.
Mr. Chair, we are committed to working with Canadian businesses and our domestic and international partners to protect the safety of Canadians and the integrity of Canada's financial system. I thank you, and we are here to answer any questions you may have. Thank you, Mr. Chair.
Well, thank you, Mr. McKillop and Ms. Ashimoff. We are now moving to our first round of questions from members. Each party will have up to 6 minutes to ask questions. We're starting with the Conservatives, and MP Lawrence, you're up for 6 minutes.
Thank you very much. And I'd like to thank Mr. McKillop for his excellent opening statement, and I might say his strong testimony in the Public Safety Committee, of which have had the opportunity to review. I just want to sort of summarize some of the testimony that you've already given so that it's clear to Canadians. Now, in the Emergencies Measures Act, they sought to give you, I don't want to say authority because it's probably the incorrect word, but additional ability to have as registers to get information from cryptocurrency and from crowdsourcing platforms. Prior to the act, and the way it stands now, because it's been revoked, is they weren't required to be registrants, and therefore you weren't getting information from them directly. Is that correct?
Correct for the crowdsourcing, that they are not considered reporting entities. Crypto dealers, however, virtual currency dealers are in fact registered with FINTRAC and have been reporting to us since 2020. Okay.
And those would constitute the intermediaries, for lack of a better term, companies like Wealthsimple, but peer-to-peer cryptocurrencies aren't currently able to or aren't required to be registered. Is that, have I got that correct or no?
You are correct. Peer-to-peer is not covered. It would be when the transactions are going through a virtual currency dealer, and we would see large cash transactions or large purchases, for example, of crypto or disbursements of crypto money, that would be reported to us. And I can defer to Donna if she would like to add anything else, as she is responsible for the compliance sector.
That's correct. Virtual currency dealers and not one-to-one virtual currency dealers.
Okay, thank you very much. So that being said, though, as per your testimony, if I understood it, at Public Safety, is that even though they, let's just stick with crowdsource funding, even though they aren't direct registrants, you do sort of have eyes to those transactions through other means, such as through Stripes and Interact, and the money and the flows into, and I guess out of as well, crowdsourcing platform. Have I understood that?
Thank you for your question, Mr. Chair. Yes. Anytime that a crowdfunding platform is used, there would be a touch point at a financial institution. There is a requirement if you're setting up a page or if you're receiving the disbursements in order to, receiving the donations in order to disperse them to others, there would be a touch point at a bank, and there would be a financial institution that would be in a position as a reporting entity to report transactions to us if they were either threshold transactions or if there were reasonable grounds to suspect that the transactions were relevant to a money laundering or terrorist financing activity.
Thank you very much. My next question builds on that. And so the Emergency Measures Act invocation gave you the ability to make crowdsourcing a registrant, but I suspect you weren't able to get very far in those 4 or 5 days, and I also suspect it had very little impact on the actual disbursement of the illegal protest. As far as you can comment on that, I realize there might be some limitations. I'd really appreciate your thoughts on that.
Thank you for that, Mr. Chair. The member is correct that we would have started the pre-registration process, but within a week, there's only so much that can be done in terms of registering. But at the pre-registration stage, anybody that, or any platform or any payment service provider that pre-registered would have been in the position to report to FINTRAC if they had reasonable grounds to suspect that the money they were seeing was relevant to a money laundering or terrorist financing activity. That being said, the Emergency Measures Act, the goal of it was really to choke off the funding to what was determined to be the illegal blockades. And in fact, it did serve its purpose.
Yeah, but that didn't go through your body. That was directly from law enforcement to the FIs. So like FINTRAC really didn't get involved at all in the cessation of funding, unless I'm incorrect, and please do correct me if I'm wrong.
No, Mr. Chair, you're absolutely correct. FINTRAC was not involved at all. The point was simply that once the funds are frozen in the financial institutions, there would be no transactions to report to FINTRAC, as there would be no transactions through those bank accounts because the accounts themselves were frozen.
Just as we go forward, I assume my time is coming to an end, Mr. Chair, but
you have 1 minute, MP Lawrence.
Okay, perfect. Maybe you could just share with the committee as we prepare for the eventual inquiry and greater study on this, were there, and I realize probably only 30 seconds, but maybe you can talk about this later, but were there learnings in that 7 days that you had, or a week or 5 days, to what it would take to implement crowdsourcing? Are there things that you learned during that period that you could share?
Thank you for the question. I do like to think that we learn all the time, but I'm not sure that we've learned or had enough time to really dig in deeply to see either the best way or the value of the reports that would come from crowdfunding platforms. For example, we anticipate that there would be, and we anticipate continuing discussions with them. I certainly don't want to talk for my colleague Donna, but I would anticipate that we will continue to explore with payment service providers and crowdfunders and others on the best way to ensure or enhance the coverage in Canada, to enhance the efficiency and effectiveness of our anti-money laundering regime.
Thank you, and thank you, MP Lawrence. And we're moving to the Liberals, MP Zarowitz, for 6 minutes.
Thank you very much, Mr. Chair. I want to actually start off with my own sort of very short statement to say, as a Ukrainian Canadian, as well as the vice chair of the NATO Parliamentary Association, I also strongly condemn Russia's unprovoked attack on Ukraine, which has already claimed too many lives and continues to put countless civilian lives at risk. I stand in complete and absolute solidarity with the people of Ukraine and its legitimate democratically elected government and parliament. I'm glad and unequivocally support our Prime Minister, our Deputy Prime Minister, and in fact, all leaders of our federal government who are condemning NATO's actions today, as well as I fully support our commitment to apply the strongest sanctions possible and to do all we can to continue to support Ukraine moving forward. With that, Mr. Chair, I want to say huge thanks to our two guests today. Thank you so much for your work. Thank you for coming before us today. I'm going to start off with this question. The Deputy Prime Minister has announced that she intends to put forward legislation that's going to empower FINTRAC to have oversight over crowdfunding and cryptocurrency platforms without the need for the Emergencies Act. Would you support such change?
Maybe I'll take that question. That really is dependent on both the Deputy Prime Minister and the Minister of Finance. And if that is to come to pass, we will obviously put in place the mechanisms to support.
Thank you. And maybe continuing on Mr. Lawrence's sort of last question and your comment right now, if the Deputy Prime Minister was saying, and she's already made this public commitment so that she's intending on putting forward legislation in order to make this permanent, is there anything that you would recommend that you want to make sure that this legislation contains? So is there any recommendation that you would make based on, as Mr. Lawrence put it, learnings, that you would say we want to make sure that it covers online crowdfunding platforms, cryptocurrencies, and it specifically sort of does something? Is there anything that you would recommend at this point?
Mr. Chair, I appreciate the question. These are certainly extensions of what we currently have in place, which are virtual currency dealers associated with money services businesses. And we would continue to leverage not only the brief experience, as my colleague had indicated, but we would look to do some research internationally. We have our Five Eyes colleagues who are equally seized with the movement of virtual currencies and these technologies and these platforms. So we would provide any advice, which I can't go into details on the provision, but certainly they would be informed by research and experience of not only this brief event, but our colleagues internationally as well.
Mr. Chair, that was a very, very helpful answer. Thank you so much. My next question is, when the Emergencies Act was put into place and FINTRAC was given new powers to monitor the online crowdfunding platforms and other payment providers, this might sound odd, but did FINTRAC have the capacity to be able to do the work for the online platforms and for the cryptocurrencies?
Mr. Chair, that's certainly a very good question. FINTRAC is a small and mighty organization, and we have many reporting entities. As my colleague Barry had indicated, 24,000 reporting entities. What we do is we allocate resources to where they're needed most. And certainly in this case, we were agile. We were able to redistribute our resources to what the priority of the day was.
Thank you so much, Mr. Chair. I appreciate that answer, and I just want to make sure that my intention was really, my intention, I think it was well taken and understood, was just so that as we're moving forward, how do we ensure that there continues to be the necessary capacity and resources as we move forward with any type of permanent legislation? And just so I could be clear, what FINTRAC was able to do with the Emergencies Act was basically, should there have been any information that was gathered, was basically to provide that information directly to the RSCMP and or financial institutions. Can you confirm that? And is there anyone else that information might have gone to?
Thank you for that and the opportunity to provide a little bit of clarification. We would not have actually reported anything. We do not give anything to financial institutions. We, in fact, receive the reports from them. So we do not monitor per se. We do not investigate. So once the reports are received, if they meet our threshold, which are reasonable grounds to suspect that they would be relevant to a money laundering or terrorist financing activity, then we would disclose that to law enforcement. It could be to CBSA as well. It could be to CSIS. It could be to CSE. We have a number of authorized and legislated disclosure recipients to whom we can disclose, and we would disclose it to whichever law enforcement jurisdiction or whichever appropriate designated recipient would benefit most from the actionable intelligence.
Thank you. I know that's a wrap, Mr. Chair. So
that is a wrap.
Thanks so much.
Thank you, MP Zarowitz. We are moving to MP Saint-Marie.
Oui,
for 6
merci, monsieur.
Thank you, Mr. Fonseca. So first of all, welcome, Ms. Akshamov and Mr. McKillop. If I pronounced your names properly, I'm sorry about my accent. And I would like to salute the comments made by my colleagues and especially Ms. Zarowitz's. It was very touching. Before speaking about the Emergencies Act as such, I would like to well understand what FINTRAC does in the moment where accounts are seized. I want to make sure I understood correctly. Let's say that there's a financial institution that sees a transfer of money that seems suspect or suspect activity in one of their accounts. So under normal legislation, the entity, the bank, would freeze the account and report to you. And then you, having done the analysis, would do the follow-up. Is that correct? Thank you for the question. It's not directly in that order, we don't give any directives at all to financial institutions. We are not at all involved in the freezing of accounts in any way. In this case, normally, they can submit suspicious transaction reports to us if they suspect that it involves money laundering or the financing of terrorist activities. If not, we don't receive any reports. Not in this case, with the Emergencies Act, they could freeze the accounts directly because they received that information from the RCMP, but we would not be aware either of the fact that they froze the account or of what account we are discussing. So we're not involved at all in that side of the economic measures. Thank you very much, Mr. McKillop, for that answer. So before coming to the Emergencies Act as such, I wanted to ensure that before it was invoked, in normal times, if a financial institution suspects that there has been some covert activity that's criminal under the legislation you named, they would report to you. So what you just explained to us is that under the Emergencies Act, it didn't come under the bill that you mentioned, the Proceeds of Crime, Money Laundering, and Financing of Terrorist Activities Act. So financial institutions wouldn't be reporting freezing of account under the Emergencies Act. That's right? Yes, it is. Thank you. Okay. Normally, per year, how many reports might you receive? Could you give us the figure you stated from what you receive from financial institutions? Thank you, Mr. Chairman. We receive about 30,000 reports per year, and that would be from all of our entities. So financial institutions would provide us with 80 to 85%, I'd say, of those reports. And the suspicious transaction reports, I believe we received 460,000 from all entities. So I understand that you are working very hard. So thank you for the work that you are carrying out. To your knowledge, do some financial institutions or have some financial institutions been able to freeze assets under normal legislation, particularly under the Money Laundering Act, and send you reports? I don't know if my question's clear. Thank you for the question. I'm not an expert on that legislation that gives direction to the banks. But I think that according to the legislation that they're under, they can decide what their level of risk is, that what they're comfortable with in working with a client. So if a client goes beyond that risk level, it's up to them to decide that they will freeze the account or decide to no longer do business with this person. So can that be indicated in a report that's seen to us as suspicious transactions? That's possible, because there's a part of that that indicates actions taken by financial institutions or by any other entity that is significant. So it's possible that that would be indicated in that way, that the account was frozen or that they de-risked the person, as we say, and they decided to no longer do business with them. So that's intelligence that becomes of interest to police forces, because if they want to have a production order, they need to know if the account is still active. So that's part of the intelligence we would provide to police forces. Thank you. So in the application of the invoking of the Emergencies Act, you weren't directly involved in the freezing of accounts. Did the government send you any requests or any directives in line with the Emergencies Act in any way? Thank you for the question. Certainly in terms of compliance and in terms of businesses that would be obliged to register with us, yes. But other than that, no. It was the enforcement of our own legislation, the Proceeds of Crime, Money Laundering and Financing of Terrorist Financing Act. Thank you. That's the end of my questions. Thank you, Mr. St. Marie.
To the NDP and MP Blakey for 6 minutes.
Thank you very much. Had the registration process continued with crowdfunding platforms and other entities that aren't covered under your normal mandate, I'm curious if you could share with the committee what kinds of information you would have been able to receive as a result of completing that registration process and the reporting that would follow on that, and how you believe that that information would have contributed to the purpose of the emergency order, or how that information would work within the context of your existing mandate.
Thank you for that question. I'll start, Donna, if you want. Defer to you, or you can jump in if you have additional information. How to continue the crowdfunding and payment service providers would have registered as reporting entities to FINTRAC. They therefore would have been subject to the Proceeds of Crime, Money Laundering, Terrorist Financing Act, and they would have submitted reports as per that act. That would have included threshold reports, as I went through earlier, into or out of Canada over $10,000, for example, large cash transactions of $10,000 or more within 24 hours. And they would have been able to submit suspicious transactions to us in the event that they had reasonable grounds to suspect that the transactions that they were looking at would be relevant to a money laundering or terrorist activity financing. And that is still the limitation. The mandate was not broadened to receive reports on anything. It was broadened to allow additional entities to report transactions related to money laundering or terrorist activity financing.
Thank you. Ms. Achimov?
Yes, Mr. President, I would just add as well, for these new funding arms of the payment service providers as well as the crowdfunding platforms, we also had under this order a requirement for the money services businesses who were already registered with us, but if they themselves had any changes associated with their dealings according to the Act, they were required to provide us the additional information. So in other words, those who were registered still had an obligation to signal if there were any changes in their business dealings and if they had any of those clientele that were involved or covered under the order.
Okay. So I'm tempted to say, because I think it sounds reasonable, that in the end, FINTRAC was not really part of the actions under the emergency orders. That may have come into play had the registration process had enough time to take place, and you may have received information in that case that was pertinent to the actions being taken under the authority of the emergency orders. But in fact, given the brief amount of time that those orders were in effect, FINTRAC didn't really get involved. Is that fair to say? Or would you recharacterize that statement in some significant way?
Mr. Chair, I would say that we jumped into action as quickly as we could. As my colleague had indicated, we're one of 13 organizations that had a role in this, and our role was to very quickly react, to stand up our website, to make sure that we were available. We fielded numerous queries from those organizations who weren't quite sure if they were covered. So the early days in terms of being able to respond to queries and to provide clarification was our role, and that was the early start. Each organization then in turn had their respective responsibilities. I think that's the fairest assessment in terms of the brief period of time and the fact that we did jump in rather quickly and respond to the queries.
Indeed. Well, and thank you for your work. I certainly didn't mean to imply that there was no work being done by FINTRAC. I was simply trying to characterize its kind of ultimate role in the operations that took place. I am curious to know if you have an opinion in terms of what if the registration process had occurred and you received that information, or if legislative changes are made such that crowdsourcing platforms and payment processors are registered with FINTRAC on an ongoing basis. Do you believe that there is a fair bit of information, or what kinds of information do you think would help you execute your normal mandate? Or do you think that that's not really required and there would not be useful information? I'm just curious to get your point of view on that.
Mr. Chair, the reality is, as we look at onboarding any new reporting entities, it is a matter of learning and understanding where the risks are and how we assess those risks and the type of reporting that we do receive. So I would say, in any instance, in ordinary times, we strive to do analysis as best as we can in terms of the quality of the information that we receive. And in ordinary times, the role that my organization plays is extensive outreach and education. We reach out to the various associations and partners and try and determine leading practices and how we can continue to provide guidance and help those interpret the guidance so that we can get the quality of the reports that are needed in terms of having the necessary action taken. So it is, my colleague mentioned earlier, we are a learning organization. We strive and we work very closely with Canadian businesses and business associations to continue to educate, refine, and adjust accordingly. So it is an ecosystem of us adapting to the risk, learning, and then training in sequence.
Thank you, and thank you, MP Blakey. And that finishes our first round. We are into our second round, members. In this round, we're being led off by the Conservatives, and I have MP McLean for 5 minutes.
Well, thank you, Mr. Chair. And before I start my questions, let me echo my colleagues around the committee here in condemning what's happening in Ukraine today by the Russian aggressors. This is a time when democracies around the world are sliding, and we need to make sure we stand fast with our democratic friends in the Ukraine and ensure that we stop this as much as we can. So moving to questions now, Mr. McKillop, Ms. Achimov, thank you very much for the work you do and for being here at our committee today to give us more information. I am going to get a little granular on here with you because you did speak, Mr. McKillop, about over the week that the Emergencies Act was in force, that a number of crowdsourcing organizations reached out to register with FINTRAC. My understanding of all crowdsourcing sites is that they are regulated at the provincial securities level, and that the decision was made not to have them report to FINTRAC because it really was a duplication of the reports that would go to FINTRAC because the money flowing into them is already regulated by at least one financial provider on the in and the out. Is that correct?
Thank you for the question. I wasn't sure if Donna was going to jump in there on the regulatory side. They are, I believe you're correct. There is some regulation to crowdfunding. I'm not sure, and I'm not an expert on who regulates the crowdfunding platforms. However, Mr. Chair, it is correct that there is always a touch point with a financial institution that is regulated by FINTRAC and that does provide reports to FINTRAC on money either being going through their own bank account or money being dispersed from their bank account to the person or the entity that set up a page, for example, a GoFundMe page. GoFundMe would have dispersed the money. It would have been through a bank or a financial institution.
Well, thank you. So in the week that you were actually getting some requests from these crowdsourcing sites to actually get set up through a FINTRAC reporting mechanism, they were just going through the reporting mechanism saying something's emerging here where we're going to have to not only abide by the current regulations that are already enforced upon them by the provincial securities regulators, but now we're going to have this extra regime, like we say, belt and suspenders, in order to kind of get through the FINTRAC mechanisms. Would that be, an overlap again, like we call a duplication of efforts?
Maybe I'll jump in here, Mr. Chair. I don't know if it would necessarily be a duplication of efforts. Certainly, the security sector and the Ontario Securities Commission, we work very closely with. Our mandates slightly differ because we are responsible on the anti-money laundering and anti-terrorist financing piece of it. So in our early days, as I mentioned, we fielded numerous queries from both crowd funding platforms as well as payment service providers, trying to understand if they are actually required and if they what their requirements are. We tried to make it easy to self-assess, as well as provide guidance from that perspective.
Okay, thank you very much. And I'm going to go back to some remarks Mr. McKillop made on here about how the intent of what the government wanted to do in the Emergencies Act by shutting off funding to these organizations that were undertaking illegal activity at the time in Canada, how that had its intended effect by cutting off funds to those organizations. The intended effect, of course, was already being done prior to the Emergencies Act through the GoFundMe cancellation. So was the Emergencies Act required in that respect in order to kind of stop the GoFundMe type of disbursements?
Thank you for your question, Mr. Chair. I don't think it's for me to determine or to say or to opine on the need for any legislation. However, GoFundMe did on their own stop the page and decide to reimburse the donors and to not allow it to the fund to continue through their platform. However, my understanding was that they then moved to a different platform, Give, Send, Go, which was less perhaps cooperative in terms of saying whether or not they were going to stop the funds happening on their page. And Mr. Chair, there are a number, I would say thousands of crowdfunding platforms around the world that are accessible. And so I think that in terms of the Emergencies Act and ensuring that any money that was raised through a crowdfunding platform that went through a financial institution to be dispersed to support the illegal blockades were in fact
Okay.
appropriately
I can
stopped.
just ask one final question
Thank you.
here.
MP McLean, we've gone well over 5 minutes, but thank you. In the next round, I guess. We are moving to the Liberals and MP McDonald for 5 minutes.
Thank you, Chair. And Chair, I just want to say, thoughts and prayers with the Ukrainian people, but also with our allies and our soldiers on the ground. Hopefully this gets resolved relatively quickly and we can all move on and learn from it. So anyway, on to questions. I just want to go back to the cryptocurrency. And I, fully understand how foreign funding could destabilize not only our economy and democracy, but I want to understand better the difference between regulated funding at the present time and cryptocurrency and how you're analyzing that.
We brought on, thank you for the question, Mr. Chair. We did bring on, as a new reporting entity, virtual currencies, which include cryptocurrencies in 2020 and 2021. And that allows us to see the flow of funding. That allows us to look at regular currency as well as that whole continuum. So with the addition of virtual currencies and the way money travels not just domestically but internationally, that is part of that whole continuum. So that was a very helpful addition.
So crypto has been around for a couple of years now, and I know you guys report on regulated funding, of course, and money movement. But I'm just wondering, have you any stats or analytics relevant to crypto raising red flags to financial institutions?
Thank you for the question, Mr. Chair. We have seen suspicious transactions from financial institutions that reference crypto, yes, and that reference crypto wallets or people using their fiat, their normal money to purchase crypto. We've also received some, I would say, excellent suspicious transaction reports from the cryptocurrency dealers themselves, as they have the ability through their own compliance program, looking out for AML, anti-money laundering, anti-terrorist financing, to identify particular wallets that are problematic and flows of cryptocurrency through different wallets that are problematic. And given that you can do this with relatively small amounts of crypto, we've seen it and have seen it to be particularly useful in our Project Shadow, which is our public-private partnership to combat child sexual exploitation material on the internet. Those that are accessing that and want to use crypto, hoping that they will be anonymous in so doing, we have received some excellent STRs that have debunked the anonymity thinking in that area.
Well, that's good to hear. I just wanted to also, since this began, the occupation basically, and then there was the narrative on freezing bank accounts, and we went through that whole process, and then the Emergency Act. At what point did you start seeing a deterrence from the crowdfunding society, or if that's what you want to call it, or was there a deterrent? Was there a point in time when these entities were enacted, or even the narrative started, that all of a sudden it started to decline?
Thank you for that question, Mr. Chair. From our perspective, in terms of seeing any reports related to money laundering, terrorist financing, there wasn't, I don't think, a point where there was a precipitous decline or precipitous increase in reporting. I think what I would say is, as all of you have seen, I think the efforts came together at the same time, and we saw the money being stopped, and we saw the law enforcement activities, which were extremely well done in Ottawa, taking place almost simultaneously. And I think it really was a combination of all the actions that brought this to a peaceful end.
How much time do I have, Chair?
MP McDonald, you've got 40 seconds.
40 seconds. I guess I'm going to ask this, and in general, how far behind are we on regulations as far as keeping up with entities like cryptocurrency and foreign monies coming into Canada to disrupt our economy and our society.
Mr. Chair, thank you. I'll take that question. I mentioned earlier that we have a regular pulse with our international colleagues and our Five Eyes colleagues, and Canada was amongst the first to recognize the fact that we did see this as a key element, and that's why we do have virtual currencies as part of our supervision framework. And really, everyone is at different systems across the world. There isn't a harmonized approach, but we were one of the first. I think it's safe to say we were one of the first countries to recognize the importance of this in the supervisory framework and as part of a deterrent.
Thank you.
Thank you.
If I may, Mr.
MP McDonald. That's the time, but maybe in another round or another questioner, we do have Monsieur Saint-Marie for 2.5 minutes.
Merci, Monsieur.
Thank you, Mr. Chairman. On the 10th of February, so before the invoking of the Emergency Act, Ontario got a court order to freeze the two main crowdfunding platforms on Give, Send, Go for the two main participants, and you referred to that, Mr. McKillop. So the order was granted under normal legislation, and it was executed under normal agreements between the States and Canada. So within that operation, did you have any role to play at all, and what was it if so? Thank you very much. No, we, Mr. Chairman, had no role to play in that, nor in the order, nor in the actions that were taken by the financial institutions. Okay, thank you. So another question. What are the communications or exchanges that you would have with regulators of securities, for example, for the financial markets in terms of regulation of social crowdfunding platforms, rather? Thank you, Mr. Chairman. We work very closely with our provincial counterparts. We have agreements to share intelligence in order to help them not only in the fight against money laundering, but also in terms of training of our agents, but also in the sharing of good practices. Thank you. And in terms of cryptocurrencies, I imagine it's the same sort of relationship that you would have with the securities regulators at the provincial level? Thank you for the question. Yes, we have agreements with several provincial counterparts. And for us, it's very efficient and effective to have these agreements in order to share, as I said, the best practices, and also really in terms of training, and in order to see what the trends are in terms of virtual currencies. Yes, that's all. Thank you. Thank you. Thank you, Mr. Saint-Marie.
And we are moving now to the NDP and MP Blakey for 2.5 minutes.
Thank you very much. I know you've mentioned before on a few occasions that with crowdsourcing platforms and payment processors that there's points of contact with financial institutions that do have reporting obligations to FINTRAC. I'm just wondering, do you believe that the exclusion of crowdsourcing platforms and payment processors from reporting obligations to FINTRAC creates blind spots that make it difficult for FINTRAC to carry out its mandate?
Thank you for the question, Mr. President. Mr. Chair, I think they're early days. We are, as I mentioned, looking at various aspects of virtual currency, money services businesses, and how those interact. Certainly, we as a country and as a regulator have an obligation to look at emerging trends. And certainly there are a number of early lessons and associated with a whole host of interactions with virtual currencies. And that's going to evolve. And new platforms and new mechanisms and new exchanges are going to take place. So I think it is up to us to to look at some of the best practices from other organizations as well as ourselves, and to evolve as the technology and as the world evolves.
In the aftermath of the emergency orders, I mean, I think one of our really important responsibilities here is to look at what happened and to try and make recommendations so that if ever powers like these have to be used again, that they can be done and used in the best possible way, and doing that in a way that that respects maximally the rights of Canadians. I'm wondering if you have any recommendations coming out of this process from where you sit on how future uses of emergency measures should roll out, including what, whether that's better government communication or different ways of implementing similar orders.
Thank you for the question, Mr. Chair. I would say that we are part of a number of government organizations. We're part of 13 government organizations, and I think we all will and continue to look at lessons learned and assess our operations as well as those in that whole continuum. So I believe we will all look at not just because of this incident, but as we look at the evolving digital space, cyberspace, we're all sharing observations and looking at ways in terms of shoring up or addressing potential loopholes and vulnerabilities. And that's an ongoing part of our business. And it has to be in this fast-paced world of crypto and digital.
Thank you. Thank you, MP Blakey. We're moving now to the Conservatives, MP Chambers, for 5 minutes.
Thank you, Mr. Chair. Thank you to our witnesses. But first, I'd also like to just mention, we often make headlines in this place for disagreeing with each other, but I think you've seen a multi-partisan, unanimous condemnation of what is happening in Ukraine. I, like my colleagues, stand with the government, with the Prime Minister in any response that is necessary to push back on this Russian aggression, which is unparalleled and unprecedented and needs to be met with serious consequences. Thank you to our witnesses for appearing again. It's nice to see you back at this committee, and thank you for your testimony thus far. My questions will be a little bit bit backward looking, but then also forward looking. I just want to confirm that I understand some of the gaps that we've identified or have been discussed. Setting aside the emergency order, if a transaction had met the threshold for reporting, just in the general sense, even if it came from a crowdfunding platform, but ended up in a Canadian bank account, that would have been, or would be reported, or would have been reported through the regular regime. Is that correct?
Thank you, Mr. Chair. That is correct. We would expect our reporting entities to report those transactions to us if they meet their threshold for so doing.
Okay. And transactions, obviously, then that would have fallen below that threshold would not have been, would not have been reported. Is that kind of similar?
Unless it was a pattern of transactions below threshold that would lead them to meet their grounds for suspicion.
Okay, thank you. And that would be the same for transactions that originate and have a destination within Canada and then outside of Canada as well?
Yes, Mr. Chair. If their suspicions and their ground for suspicions are met, those are not considered threshold reports unless they're outside of Canada or coming into Canada and they're over $10,000 within a 24-hour period, or if it's a large cash transaction of $10,000 or more.
Okay, thank you. And then in terms of, we have heard about like specific gaps. Since some of these transactions may have been identified, are there transactions that were not identified that ought to have been identified that future legislation may address by including the crowdfunding platforms? I'm just trying to understand exactly kind of what that gap might be that we're looking to address.
Thank you, Mr. Chair. It's hard to say right now, not knowing what transactions a crowdsourcing or a PSP, a payment service provider, would in fact see that is not currently seen. I think time will tell, and there is some additional work that we have to do in terms of looking and working with them in terms of the transactions that they do see, and whether or not the transactions that they do see would allow them to meet their grounds for suspicion. I would assume, and I'm guessing here, that on a normal crowdfunding page, we would not likely see transactions of $10,000 or more being donated to a particular cause.
Right.
So we may not see significant numbers of threshold reports, but it is possible. And again, time will tell in terms of what types of transactions they see, whether or not a pattern of transactions would lead to grounds for suspecting money laundering or terrorist financing.
Okay, thank you. So thinking ahead, if we, address some of these gaps with legislation, I'm also thinking about potential other gaps that may still exist. So I'm contemplating situations where an entity actually fundraises directly without the use of a fundraising platform and accepts donations both domestic and foreign, and what obligations that entity would have to report any suspicious activity to FINTRAC.
Thank you for the question, Mr. Chair. In the case, it almost sounds like the question is referring to an existing entity. They're not for profit or a charity or something like that. In those cases, they are captured by virtue of having a bank account, or if they have a cryptocurrency wallet and they wanted to transfer that money and they were transferring it to a known suspicious wallet, our cryptocurrency dealers that do report to us would likely catch those transactions and report them to us. And any non-for-profit or charity organization, as we've seen in the past, where our financial intelligence has been helpful in addressing charities that were being misused, that the reporting that we receive from our current financial institutions has been extremely useful in that sense.
Thank you very much. I believe that's my time, Mr. Chair.
Thank you. And thank you, MP Chambers, and for your remarks on Ukraine. And now we're moving to the Liberals and MP Baker for 5 minutes.
Thanks very much, Mr. Chair. And I, too, would just like to make a brief statement if I could. I want to, first of all, thank my colleagues for their thoughtful and strong and supportive statements. MP Chambers took the words out of my mouth, but I was going to say that, we disagree on so much here at this committee and in the House and in public discourse, but this is something that we are all united on, which is so important and I think means a lot to Canadians. They want to see us united on this issue. I will just quickly say I'm of Ukrainian descent, and my grandparents, like so many people of Ukrainian descent, have risked their lives and lost loved ones to that desire for freedom and independence. And of course, those with Ukrainian ancestry are touched by this very personally today. But I think this is something that concerns all of us and touches all of us. And that's what we've heard from the comments here today from all members. Touches us because we see a free and independent country being invaded unjustly because of the humanitarian crisis. And I think this is a threat to the international rules-based order that protects all of us. So what we're seeing today is a threat to not only Ukraine, but to the rest of Europe and our allies and to Canada. And that's why it's so important that I think we take the steps necessary to make sure Vladimir Putin doesn't win and that Ukraine is free and democratic and independent. And I thank all members for their thoughtful statements. With that, I'd like to move to my questions, Chair, if I may. There's been quite a bit said and reported on with regards to the funding, the blockades coming from outside of Canada. And can you talk about FINTRAC's ability to examine or track suspicious transactions originating outside of the country?
Thank you for the question. Mr. Chair, FINTRAC does not monitor transactions, nor do we have any ability to see transactions going to any institution or any GoFundMe type page or GiveSendGo page or any other crowdfunding platform. That is not within our mandate. We do have very good partnerships with not only our Five Eyes, but with a number of international financial intelligence units, FinCEN being one of our biggest partners in the US. Certainly they were alive to this issue that was going on and to the blockades. We had discussions with them. They were certainly knowledgeable and alive to the fact that any suspicious activity reports that they may receive, that they would forward them on to us if it was applicable and if it would assist us in our intelligence job. But in terms of any activity coming from foreign donors or people living outside of Canada, these crowdfunding platforms are in fact available internationally as they are on the internet. Anyone from around the world could have donated to what was initially a cause that they felt that they wanted to support. And we would not see those donations unless, of course, they were $10,000 or more and coming from outside Canada. But smaller donations made by individuals to support a cause that they believe in, we would not see that unless it came into that particular cause and was deemed suspicious by the bank that was holding the bank account for that particular cause.
Okay, that's helpful. Thank you. Just in practical terms, like I'm thinking about my constituents who might be watching today or Canadians who are watching today, and they've heard a lot of news about FINTRAC's role in this, and we've talked a fair bit about cryptocurrency, but just in practical terms, sort of what was the impact of the requirement to have crowdfunding or cryptocurrency platforms register with FINTRAC? What steps, what actions were you able to take as a result?
Thank you for that question. I believe the initial act of registration and the conversations that were had. So a number of crowd funding platforms as well as payment service providers paid attention. They started to question. They came to us. They wanted to understand what was required, what they had to do, and how they were implicated and what their requirements were. So I believe that it was a very early intervention in terms of creating awareness, having those questions come in, and helping those organizations self-identify fairly quickly to see if they were possibly covered and if they had activities that they wanted to report. And we made it very easy prior to even being registered. We enabled any suspicious transaction that these new organizations would have had to allow them to surface and to register those.
Okay, thank you.
Thank you, MP Baker, and thank you for those heartfelt words in how Canada is supporting Ukraine and the work you're doing here on the ground. We are moving members into our third round, and I have the Conservatives up. I believe it's MP Lawrence is up for 5 minutes. Is that correct?
MP Lewis.
Sorry. I wasn't sure. I thought I had a change, but MP Lewis. I apologize. MP Lewis, welcome to the committee. It's great to have you here.
Well, thank you. Thank you very much, Mr. Chair, and thank you, colleagues. And I'm gonna echo it too, because if I didn't, it would be wrong. I've been watching very closely this morning, unfortunately on CNN, but you've got to get your news somewhere. And my heart is with all of the folks of Ukraine. And honestly, although we have work to do here, I would like to just be quiet for 5 minutes and just close my eyes in solidarity with each and every one of you to really think about the families being affected in Ukraine. And so I won't, but that's where my heart's at today. And just thank you to all of my colleagues. I guess especially Mr. Baker, I can see the pain in your face, sir. So just thanks for being open and honest and humble enough to really recognize where we're at. And so first and foremost, I want to say thank you, friends. I've never been part of finance before, so perhaps I'm a little bit in left field. I do sit on International Trade Committee, so if my questions are perhaps a little bit sideways, please forgive me on that front. But I do want to tie in the international trade side of things. My riding of Essex is right beside the Ambassador Bridge, so you can appreciate where I'm coming from for this. So the first question I would ask, if we highly regulate crowdfunding platform in Canada, won't Canadians just switch to crowdsourcing platforms abroad? And I don't know who, Mr. Chair, to direct this to specifically, but please do, whoever would like to take that first question, please do.
So maybe I'll start by saying thank you for that question, and maybe I'll just step back a little bit. When we look at supervision or regulation, we really do keep Canadian business first and foremost in our minds, and we take a look at the need for a policy change, the burden on business, and privacy implications, and those three areas always come into play. Certainly, the role that small businesses, medium businesses play, and corporations in Canada, they have a role to play, and I think it is incumbent on us to look at, as I mentioned earlier, emerging threats, risks, and then balancing those in terms of trying to find the right equilibrium in terms of bringing forward reporting entities and their obligations to help fight financial crime.
Thank you so much on that. Perhaps through you, Mr. Chair, to Mr. Makalop, if I mispronounced the last name, I apologize, sir. I think I'm directing the question to the right way there. I'm just curious. So are there other countries, specifically the United States, that have a similar, I'm going to say, agency as to what FINTRAC has, or what FINTRAC does, and or if it's not in the United States, is it across the world? So do you have, folks outside of Canada that you lean on as well?
Thank you for that. Thank you, Mr. Chair. Yes, there are just about every country that's in the financial part of the Financial Action Task Force would have a financial intelligence unit. Your question on whether or not they do what FINTRAC does, I would unabashedly say that FINTRAC is the best in the world in terms of the intelligence we provide. We have international surveys that will indicate that. We are one of the few that actually does financial intelligence to support our domestic law enforcement. Many of the financial intelligence units around the world specialize in supporting the international component and sharing internationally. We do that as well, but we do tactical financial intelligence support to law enforcement and national security agencies in Canada, and that is relatively unique. Certainly in terms of the number of disclosures we do a year, the number of investigations we're involved in with law enforcement, and the number of times that we are recognized as a partner in successful investigations is unique internationally. So yes, financial intelligence units do exist around the world, but I would say FINTRAC would be in the top in terms of what we do and how we do it.
Well, that sure puts a smile on my face. We need some good news today. So thank you, Mr. Makalop. That's excellent. And so just a very quick follow-up question to that then. So do you have, does FINTRAC, are you guys able to talk to the other agencies? Or is it like a solid at the border and you do your own thing and the other agencies do their own thing?
Thank you for that. No, we actually talk quite a bit with them. We certainly have our Five Eyes partners, of course, with whom we have a significant number of projects that are ongoing, whether it's on, for example, on the tax evasion side or on the terrorist financing side, or even on trade-based money laundering, for example, where there are connections across the world sometimes in these cases. And we have done and are working on cases that do touch a number of different countries, and we work together in sharing that information. We can query other countries, for example, if we have Canadians who are involved in using another country's banking system in order to hide their proceeds of crime. We can contact the other country through the FIU. We will get reports that we can then forward on to our own law enforcement in Canada. And they do the same, and they do call us. We have constant contact, more so with our Five Eyes partners, of course. However, we deal with just about any country with whom we have an MOU and that we can share information and intelligence with. They will do that. That's on the intelligence side. We also have supervisory MOUs with our Five Eyes where we can share supervision information as well as best practices, training and learning. And we also work through the Egmont group, which is a group of financial intelligence units around the world, to support them in their ongoing training as well, and some of the standards and some of the work that we do as international financial intelligence units.
Thank you very much, Mr. Malakoff. Thank you, Mr. Chair. I know I'm done.
Yeah,
Appreciate
no,
it.
thank you, MP Lewis. Thank you for bringing that trade lens to our committee. And we do have the Canada-Ukraine trade agreement that we're all very proud of. So thank you on that. We are moving to the Liberals and MP Chattel for 5 minutes.
Merci. Thank you. Thank you very much, Mr. Chair. First of all, I would like to add my voice to the voices of my colleagues to express my solidarity with the Ukrainian people. Today, Ukraine has been plunged into terror, into darkness, and it is totally unjustified by Russia. This is an affront to democracy, to life itself, and it's inexcusable. Canada stands with the Ukrainian people, like all the international community does, to bring in an end to this terrible situation. Thank you to all our witnesses who are here today. Thank you to FINTRAC for all your experience and your very fundamental, important work that you do. I have a few questions. I personally have been very concerned about the fact that foreigners can fund, or even far-right groups can fund activities of groups in Canada. It is, for example, if you just think of the blockade at Windsor, there was some billions in economic damage. These are not strictly terrorists, but they are foreigners, people from foreign countries who give money to activities that create harm and damage to our economy, substantial damage. So this is my question. Without the elites of GoFundMe, without that, are you able to find out who the donors are? All of those who funded? Thank you so much for your question, Mr. Chair. Certainly, we don't use leaks, nor do we speak of elites. Those who donated to that cause did so. But as far as crowdfunding platforms are concerned, unfortunately, they are available to everyone. Anybody can donate. With respect to one like Stripe, certainly there were people who supported the cause before it was declared illegal. So I think that there were people around the world who were fed up with COVID, who were upset and saw the demonstrations against COVID. And I believe that they just wanted to support the cause. It was their money, their own money. So it wasn't money that funded terrorism or that was in any way money laundering. Whether you look at any crowdfunding platform, they will not give us the name or the names of the donors unless there is a direct link with anti-terrorism or with money laundering. Well, thank you so much. We know that this is something that was worldwide, and that money is often hidden in tax havens. But when you see significant suspicious amounts of money that can be found on crowdfunding platforms like GiveFundMe, and which are contributed by foreign forces, foreign groups. Do you have the tools necessary to ask for information or to obtain information about those kinds of platforms?
Merci pour la question, Monsieur le
Thank you very much, Mr. Chair. No, we do not have any investigative powers, so we cannot obtain information about that. But if these entities are reported, I'm so sorry, Ms. Chatel.
So we are moving to the block, Monsieur Saint-Marie, for 2.5 minutes.
Merci, Monsieur.
Thank you very much, Mr. Fonseca. The Journal des Affaires has just published an article from La Presse Canadienne, CP, where the gentleman who is the director of intelligence training for the Manchester Society expressed his concern about the situation. That is, that using this legislation would create a precedent. He said that we know that the RCMP gave lists of persons in financial institutions, and the gentleman in question, Mr. Manchester, said that the banks could then continue to prosecute those people who made private donations. And that there was mechanisms in place, a mechanism in place to link that with the money laundering element. Well, thank you for your question. No, I was not aware of Mr. Manchester's comments. But to my knowledge, the Emergencies Act was limited for a limited amount of time. It is not indeterminate. And so that means that it was very limited. What was in the Act could only be used specifically in a specific time frame for specific purposes. And I tend not to think that they would use the list of names for that purpose. But in any case, if it were a document that says we have some suspicion here because we have received names from the RCMP, we would like to have information. We would like to give you information. I would not take that information because in any case, the police is not entitled to give a guideline or a directive to a bank about what they should do, nor can we ask a bank to open an operation about some doubtful transactions. So really, you can't ask a bank to do something that we cannot do legally. So the RCMP does not have the right, or any other police force for that matter, to give a directive to the bank with respect to reporting to FINTRAC for the purpose of obtaining evidence or proof to proceed with any type of accusation. They don't need to look at that. They don't need to see the names. If people are suspicious or if there is something that would suggest that they would be involved in money laundering, they would be identified by the financial institution. Thank you.
Merci, Saint-Marie.
Thank you, Mr. Saint-Marie.
We're moving to NDP, and we've got MP Blakey up for 2.5 minutes.
Thank you. So I guess I just want to follow up on that. What I took you to be saying, and I do, I normally listen without translation. I was listening without translation. I'm usually pretty confident in my French, but what I took from your testimony there was just explaining some of the reasons why Canadians should feel reassured that whatever information was transmitted in this process wouldn't leave a lasting impression on their record in the private sector. I'm wondering if you could just take a little bit more time to explain that, so members of the committee including or perhaps especially myself, feel that they have a strong command of your comments in response to Monsieur Saint-Marie.
Thank you for that. Mr. Chair, I hope it's not because the quality of my French was not up to par that this wasn't clear. Really, the Emergencies Act was time limited, and it was for a specific event, and the information on the designated people that were given to the banks, for example, the financial institutions and others, were for funding related to the illegal blockades and the role, and to ensure that the funding that was received or dispersed was stopped. So the banks, once this emergency measures has been revoked, as it has been, the banks could not use that information, for example, to submit an STR to me to say, hey, we got this name from the RCMP. Looking backwards, yeah, the person's a criminal, so we're going to give you this. And if they gave that to me and said, the RCMP gave me this name, so I'm giving you, this is my threshold for reporting to you, it is not something that I would be comfortable disclosing back to the RCMP, because it's something that the RCMP, and I use RCMP as a generic term for law enforcement here, law enforcement cannot go to a bank and direct them to send an STR to FINTRAC on any particular individual. There are legal requirements. If the RCMP or any law enforcement wants that information, they need production orders, they need warrants from the court. They cannot simply walk in and say, please submit an STR on Barry McKillop to FINTRAC, so then they can give that to me as intelligence, and then I can go get a production order and charge someone. I'm not a constitutional expert, I'm not a lawyer, but that is contrary to how our court system works. There is an independence, the threshold is done. The banking system or the financial institutions would submit reports to us on people that they believe are, or they suspect are involved in, or that their transactions would be relevant to money laundering or terrorist financing activities. So the fact that they were either supporting or dispersing the funds related to an illegal blockade has nothing to do with money laundering or terrorist financing. We would not get a suspicious transaction. And I do not believe that the intent or the reality would be that the banks would keep the list of these names once the process has been done to unfreeze the accounts, as Madame Jacques was mentioning the other day. These accounts will be unfrozen. It's not a lasting black mark on these individuals. They simply cannot use that money or whatever it was that they had to support the illegal blockade as per the Emergency Measures Act when it was in place.
Thank you. And thank you, MP Blakey. I hope I get this one right. We've got the Conservatives, and is it MP Lawrence this time? Yeah.
You got it, Mr. Chair.
There you go.
Thank you. Mr. McKillop, I just want to sort of, I want to confirm something that came out of my last question. So just to be clear, and despite, I imagine you were working around the clock to implement the Emergencies Act at your department, but despite your best efforts, nothing that gave you additional authorization or that gave FINTRAC additional or authorization helped at all in ending the illegal Were you there?
Point of order, Mr. Chair. I couldn't hear. Point of order.
Yeah. I wasn't sure if it was my system. Yeah, MP Lawrence. MP Lawrence, I think we lost the last 10, 15 seconds of your question.
Well, we lost the whole question.
That's a shame.
Maybe the whole question. If you could go over again, please.
Can you hear me now?
We can.
Okay. Yeah, it was the greatest question I've ever asked. So in all seriousness there. So I just wanted to be clear from the last question, or from my last question round, that the additional powers given to FINTRAC in the Emergency Measures Act invocation or proclamation did not help in resolving the blockades or the illegal protests.
Thank you, and thank you for the question, Mr. Chair. I kind of hesitate to say that FINTRAC didn't have any role at all, but you're correct, because we were working 24 hours a day, and we are part of the security intelligence community in Canada with the federal government. But you are correct that the authority to register crowdfunding platforms and the payment service providers. While it may not have had a direct impact, it may have in fact reinforced the fact that it was at that point illegal to try to donate money to support this blockade or to take money out. And it did certainly put a focus on that, and it put a focus on the banks and the financial institutions that may have had any control of any goods or any accounts related to any of these crowdfunding platforms. And they probably looked at other crowdfunding platforms as well that were not necessarily mentioned in the newspapers, for example. So I think there was a role, but it was certainly not a direct role in stopping this.
A direct role. And so just there, I'll pivot to a different area. My concern, and I think Mr. Blakey might have pointed out as well, my concern is that it does appear that we have a hole in sort of money laundering dragnet. In that, if you have a foreign entity that is either giving to a foreign crowdsource or even to a not-for-profit, so let's say, for example, a group that wanted to stop pipelines and maybe international actors such as Russia would want to support those type of groups or those crowdsourcing platforms. We don't really have a way to Indian financial institution. Correct me if I'm wrong.
Thank you for the question, although you were cutting out, sir, and I didn't hear everything. But Mr. Chair, I'll do my best to answer the parts that I did hear. If there were monies coming in from an international organization or an individual internationally, and they were in sums of more than $10,000 or more, we would see that because it would use the international transfer system. And those transactions are threshold transactions that would be reported to FINTRAC. If the transactions were coming into a crowdfunding platform, the crowdfunding platforms that I have researched so far all have fairly strong anti-money laundering, anti-terrorist financing compliance programs in place because they don't want to be misused. And the terms of reference, as we saw with GoFundMe, if you're not managing your terms of reference, they will cut that page off. They will be certainly keeping an eye on that. Any organization or individual that's setting up a GoFundMe page for or any other type of crowdfunding page for nefarious purposes would nevertheless have a bank account if they're in Canada. So not only would we see the international transfer of threshold funds coming in, but we would also have the bank keeping an eye on whether or not the bank account that was set up for this particular social cause or whatever cause it was, that the bank account was actually dispersing the money for the purposes for which it was set up for. Otherwise, we would see suspicious transaction reports.
Thank you. And thank you, MP Lawrence. And now we're moving to MP Zarowitz for the Liberals for 5 minutes.
Thank you so much, Mr. Chair. My first question might be slightly odd. In the short amount of time that the Emergency Act was in place, and FINTRAC, thank you very much, was working 24 hours a day, thank you. What happens to the information that you collected? Does it just sort of stay on reserve? Is it eliminated? What happens to that information?
Mr. Chair, thank you for that question. Information disclosed or received by FINTRAC with legal authority while the order was in effect will be treated in accordance with our legislation and the Privacy Act. We have rigid safeguarding of personal information, and that's critical to the way FINTRAC operates. It's hardwired in terms of our the Act and in terms of our mandate, and so we have clear principles in terms of how we manage that information. As of yesterday, when the order was revoked, all activity associated with any information that we have received had to stop, and it did stop.
Thank you. My next question is, and this is in the spirit of sort of moving forward and assuming that the Deputy Prime Minister is going to continue to move forward and try to introduce legislation to make this something permanent for FINTRAC. One of the things that is that has been said about FINTRAC investigations is that it very rarely leads to charges connected to money laundering or extremist financing. And the reason that's given is because, and this is something that's been said by Transparency International Canada. They said that the reason this is the case is it's largely because law enforcement agencies are hesitant to take on labor-intensive, time-consuming cases. So one, my question to you is that true? And then two, if it is true, is there something that we need to be thinking around in terms of capacity, in terms of resources, in terms of how we're actually framing sort of any type of legislation or including in any type of legislation moving forward?
Thank you for that question. Mr. Chair, I think the member is correct that if we measured success based on the number of successful money laundering or terrorist activity financing prosecutions we have in Canada, we may not come out with significantly high numbers. However, if we look at the disruption of criminal organizations or the disruption of potential terrorist events, where our financial intelligence may or may not be recognized because it's not recognized in every successful investigation or prosecution, I think the disruption is significant. And I think that the financial intelligence is critical to assisting our law enforcement partners in their investigations. Whether or not, certainly money laundering charges are difficult. They're difficult to prove. They're difficult to get prosecutions. But in terms of my own level of satisfaction with my work, while getting a money laundering prosecution is great, if I can assist law enforcement in identifying 12 victims of human trafficking and getting them out of a human trafficking ring so they can become 12 survivors in Canada's society and Canadian society, I see that as success. Perhaps the human trafficker will not be charged with money laundering, but they will be charged with human trafficking and we will save the victims. So I think it's the measure of success that, yes, Transparency International may have looked at the FATF measure, which is money laundering and terrorist financing prosecutions. For us, we believe that while that's important, saving victims, getting victims out, avoiding terrorist incidents, and disrupting organized criminals is as successful as a money laundering or terrorist financing prosecution.
Okay, thank you. Maybe my last question is, and again, this might be an odd question. If we were to add cryptocurrency or and crowdfunding, sort of as part of sort of the monitoring powers that FINTRAC would have, is there anything that we would have to change in terms of definition around terrorism or or money laundering because of these digital features? I don't think so, but I just want to pose the question to you.
Thank you for that question. I don't believe that money laundering is linked to fiat or anything else. So any virtual money, any crypto money can be used in money laundering and terrorist financing. There would be no need to change the definition of of the type of currency that's being used to launder.
Okay, thank you.
As long as it's a proceeds of crime, it would be considered eligible for money laundering.
Thank you so much.
And thank you, MP Dzerowicz. Members, we are moving into our final round. I'm just looking at the time, and as we do on this committee, when it doesn't allow for a full round, we will divide the time up equally among the parties. We are starting for 4 minutes each with the Conservatives with MP McLean.
Thank you, Mr. Chair. And I'm going to go back where I left off after my last round of questioning. And the question that I have, I'll revisit, that all these Canadian crowdfunding platforms are regulated through provincial securities regulators we talked about. So they are covered in FINTRAC when the transactions go there. The crowdfunding platforms in Canada, specifically GoFundMe, are regulated. And when it was determined that the activities were deemed to be illegal, they ceased providing funds to the organization. The one gap we have here, of course, when Give, Send, Go, an offshore non-Canadian entity where some Canadian funds were going and some other funds were also going. We're not sure where that fits in the regulation. So that's where we are. So this is the part I think that concerns many of the members around this committee, is the implications of foreign funds, foreign organizations that are not regulated by Canadian institutions such as FINTRAC to actually destabilize, operations in Canada, government in Canada. So is this, I'm not sure how FINTRAC is going to be able to regulate these foreign platforms. Can you comment on that, please?
Maybe, Mr. Chair, thank you. In terms of looking at the gaps and looking at the regime and our regulator partners, certainly we are having conversations with them, and additional gaps and policy gaps really come under the purview of our colleagues at the Department of Finance. And I think that question would best be rooted to them.
Okay, thank you. The issue again with the Emergencies Act is it seemed we were clear that everything was going according to the law. The only gap we seem to have here in understanding is what the regulation of the foreign entity as far as distribution of funds to a Canadian illegal operation, if you will. The issue we have as far as freezing bank accounts go in Canada, and that was the order in council that was issued, freezing bank accounts for participating in the illegal activity, even when the activity wasn't illegal or deemed to be illegal, is our basic overstep, if you think, I think that where many of our constituents actually really balked at, is this going to destabilize the Canadian financial system if the government has the ability to reach into accounts where people, when they participated in that action, were doing nothing illegal, but suddenly had their accounts frozen. I'm not talking accounts $10,000 plus. I'm talking, your ma's and pa's that may have given to an organization that was not performing anything illegal at the time. Can you comment on that, please?
Thank you for that question, Mr. Chair. That the seizing of the bank accounts and the invocation of the Act is well outside the purview of FINTRAC, so I do not have a comment on that.
Okay. Anything else that you'd like to comment on? Because it seems like the Emergencies Act didn't have any role to play in the actions as far as the accounts go, the crowdsourcing. It seemed to be actually occurring under current Canadian legislation, and the Emergencies Act was really not required in order to freeze any of those accounts. And the account freeze is the one overstep here that seemed to actually as part of the Emergencies Act was really the gross overstep. Any comment on that?
Again, Mr. Chair, that is outside of the purview of FINTRAC and the role that we play in terms of money laundering and terrorist financing.
So would anything be accomplished with that?
Thank you, MP McLean. Yep, we are moving to the Liberals and MP McDonald for 4 minutes.
Thank you, Chair. I'm getting to, look, I do want to say the last time FINTRAC was in, and this time, of course, I learn more and more all the time. And it's certainly assurances like organizations like FINTRAC that is certainly appreciated. And even mentioning the human trafficking relevant to what you do is most beneficial. And I certainly don't know how you deal with the flood of misinformation and disinformation that we've seen over the past few weeks. But I'm going to go back to maybe more of a local issue when you're dealing with financial institutions such as likely a credit union or something relevant to that. What are the weaknesses that you see of those institutions, I guess, that could have consequences in you trying to do your job? Or what changes would you like to see to those institutions to embetterment for you doing your job?
Mr. Chair, I think some of that is answered in in terms of having robust compliance programs. So whether we're talking about credit unions or financial institutions, we go to great lengths in terms of educating and strongly endorsing the requirements to put a robust compliance program in place. So appointing a compliance officer who's responsible for a program, developing policies, procedures, conducting risk assessments. Those are key fundamental approaches for a robust compliance program, ensuring that they have training programs and that they monitor the evolution of risk and those training programs. And then part of our education, I must go back to what my colleague Barry had indicated. Every time FINTRAC is mentioned in terms of a successful law enforcement operation, and especially when we can put a human face to the damage associated with money laundering or terrorist financing, we bring that back to our reporting entities and the institutions. They have to understand how they play a very critical role in terms of not only mitigating the damage, but really having that robust program where they know their clients, and when something is wrong, that they have reasonable grounds to suspect and that they come back to us. So for us, I think the best way for us to continue is educating and ensuring that we have sound appreciation for the roles that these entities play in disrupting financial crime.
Thank you. I'm good, Chair. Thank you.
Okay, thank you, MP McDonald. And we are moving to the block, and MP Saint-Marie for 4 minutes.
Merci, Monsieur.
Thank you, Mr. Chairman. So I come back to the article in the Canadian Press in the business section where Mr. Manchester was being interviewed. So I would ask you once again to comment. The government asked financial institutions to check if their clients seem to be supporting the protesters. Mr. Manchester fears that in the future, financial institutions will be able to carry on with this kind of surveillance. It would be a precedent. So could you comment on that, please? Thank you for the question, Mr. Chairman. I don't know what the internal processes are for these financial institutions, but I don't believe usually when there is this kind of information that's shared, it's shared for a very specific reason. And if the information is used to some other end, usually it wouldn't be acceptable. And it's not something that financial institutions would do. But I don't know. I don't work I don't work for a financial institution, and I don't know what their processes are that they follow. But the intent was that the information be used for very specific ends for a very limited period of time. Okay, thank you very much. Another question that came from Mr. Manchester was to see, for the few days that the Emergencies Act was in effect, was to see to what degree the government might have asked your organization to put a lot of resources to use under the Emergencies Act with the siege in Ottawa. As your resources are very limited, at the beginning of this meeting, you reminded us to what degree you deal with a significant number of reports, etc., and that you weren't able to do the rest of your work well, given that you had to take steps under the Emergencies Act. So I don't know if I was clear in the way in which I expressed myself, but if so, please, I would ask you to comment on that. Thank you. Mr. Chairman, perhaps I could begin, and if my colleague wants to add anything, I would invite him to do so. As an agency for us, as I explained before, we are a small agency, and we are very agile. It was a crisis, a national crisis, and we reacted. And allocated the significant resources that we needed to for this goal, and that's the way we manage our daily work. When there are needs, we direct our resources to them. And we did this quickly, 24 hours a day, and we did a great deal of work. But this is our life. We have to act and reallocate our resources as required. I thank you very much, and I salute you for all of the work that you do. So the fact that you redeployed resources under the Emergencies Act will not harm the other activities that you're normally carrying out? No, it certainly won't, Mr. Chairman. It's clear that we have put people specifically on this initiative, but it did not prevent us from doing the work that we had to do in any case. So the fact that we worked overtime and so on, it comes along with the territory. It was a crisis, not the first, and it won't be the last, unfortunately. So we do have a capacity and we have the will. All people who work at FINTRAC want to be involved, and so it's easy to find people who want to put in the necessary time to deal with a crisis. I thank you very much. Thank you. Thank you, Ms. MP Saint-Marie.
Got NDP MP Blakey up to 4 minutes.
Thank you very much. So I think just kind of at the end of our meeting today, it might help to just step back and take a little bit of a bird's eye view. I think part of our role here on the committee is to address concerns that Canadians may have that some of the extraordinary powers granted under the emergency orders were improperly used or abused. And so I'm wondering, if you have any advice for the committee on who else we should be talking to or what questions we should be asking to discover to the best of our abilities if that's the case. And if that's not the case, to be able to reassure Canadians that things unfolded as they should have under the orders, and that and how to follow up if they're concerned about lasting consequences, say with their financial institution or anything else, and if there are to be no lasting consequences for them, how they might be able to feel reassured that that's the case, and who to pursue those questions with, and what we count as kind of getting to a point where they should feel satisfied that those questions have been answered. So I'm just wondering if you have any recommendations for the committee on how we can undertake to do that, those two tasks. Satisfy ourselves that there haven't been abuses, or to find them if they're there, and then in the event that there haven't been, how to provide reassuring advice to Canadians to that effect, and some advice on how they can pursue those questions further in their individual case to satisfy themselves.
Thank you for the question, Mr. Chair. Far be it for me to suggest who you should invite to your committees. If they're people I know and they don't want to come, I may make enemies. So certainly there were a number of agencies involved, and in terms of the individuals, be they constituents, be they Canadian citizens, of which they are constituents, I think follow up with their actual financial institution. If they were caught up in this, I think immediate and direct follow-up with their financial institutions will allow them to achieve a measure of comfort in terms of their bank accounts, as Ms. Jacques said the other day, being unfrozen now that the act has been revoked. And I think that they can follow up with their institutions and have a discussion about any impact, if any, that they would see, or that their banks, their financial institutions may have questions for them. I'm sure they can answer those questions and get that level of comfort. As for the bird's eye view, I understand that there will be an inquiry that will take place, and I think that many parties will be invited to that inquiry, which will provide a very nice overview, I'm sure, of everything that was done, how it was done, and why it was done. And from my perspective, I'm satisfied that it came to a peaceful end. Being in Ottawa every day and living through that, I was quite happy and proud of my law enforcement partners and the way that they resolved this. So I think I would leave it at that rather than suggest specific names of people that you should invite.
Well, thank you very much, and I'll leave it at that as well, Mr. Chair.
Well, thank you so much, MP Blakey, and members. I think I speak for all of us when I say that Barry McKillop and Don Ashimoff have been excellent witnesses. We want to thank FINTRAC for being with us, for the many answers that you gave us to the many questions. It was great insight into what FINTRAC does and how it does it. I also, and I say this on behalf of the committee, the clerk, the analysts, the interpreters, everybody that makes this operation work, the staff and members. I just want to say to all of you, I've never been prouder just to listen to you. Your heartfelt comments. You spoke, like I said, from the heart. You spoke strong. We spoke united. And to on Ukraine, and to hear from all. I'm sure all of our colleagues, party leaders, Prime Minister, the Deputy Prime Minister would all be very proud. And I thank you all for what you've done. I believe this is the first committee that has actually, since the conflict has begun, that has been able to make these type of comments for the public, for those to hear us and what we have to say. Thank you, and I think on that I do see a hand up, and MP McLean has his hand up. MP McLean.
Thank you very much, Mr. Chair, and I just wanted to echo your comments. This has been a very productive committee. And including on the comments that we received around the table today. I want to say goodbye to everybody. I don't know that I would have that chance, but this has been a very, very good committee to be part of. I think you all probably know I'm moving on to a different committee as of next week, and I will enjoy coming and visiting whenever you invite me, but I will be having different responsibilities next week. So, to mes collègues,
to all my colleagues of each party, I am going to miss you. Thank you, and I hope to see you soon, my friends.
MP McLean, we will miss you. I'm sure we'll see you around, and please join us as a sub any day. So members, on that, we'll adjourn. Okay, have a great evening. Thank you.